Abdurrahman, Idris, are we ready on those matters?
Yes.
Yes, we are, Your Honor.
On the record, in the matters of the people of the city of Lansing versus Abdurrahman Idris, file number 23-00167 and 169. Council appearances, please.
Matt Staples on behalf of the city of Lansing.
Assistant Public Defender John Lee on behalf of Abdurrahman Idris.
Thank you. And how are we proceeding on these matters? There's two pre-trials. One is for an assault and battery. The other is for a urinating in public and an hinder, obstruct, oppose an officer.
Your Honor, at this time, Mr. Idris is being evaluated for competency, and we are still awaiting the results of those competency evaluations. So we're asking for an adjournment until that can be completed.
Which matter is he being evaluated on?
He has several cases. Let me pull up some of the case numbers. This would be in regards to several state cases, including 23-00167 and
The staff will get it set so that they'll all fall in tandem with each other once we get a report. That way we don't have this just being randomly set.
that would be excellent. Thank you, Your Honor.
Thank you. You're all set, Mr. Idris. Mr. Idris, you're all set. You're free to go.
It's good.
We let the deputy know that he's done. Okay. Amanda Dodge. Do you have an attorney?
No, Your Honor.
Okay. Mr. Staples, did you already meet with her?
I have, Your Honor. We've spoken earlier in the day through email.
Okay, sounds good. We're on the record in the matters of the people of the city of Lansing versus Amanda Marie Dodge, file numbers 22L2768872 and 71. Council appearance, please.
Matt Staples on behalf of the city of Lansing.
Okay, and Ms. Dodge is present via Zoom without counsel. Today was the date set for a pretrial and an explanation hearing. We have a pretrial on a failure to display ops and then an explanation hearing on a no proof of insurance. Mr. Staples, is there an offer on these?
Your Honor, Ms. Dodge was able to provide me with her insurance, so the city would be moving to dismiss the no proof of insurance count. And then in regards to the failure to display ops, Ms. Dodge is currently working on a resolution of the judgment that is holding her back from being able to obtain her license. That's an ongoing process. She is working on that diligently, so we would just ask that this be set out perhaps another 30 days to give her some more time. I believe she still has to go in front of the court and get a payment plan put on the record for that judgment. So I think that's enough time, Ms. Dodge. If you have a next court date, would you provide it to the court?
Yes.
Okay, you don't have a next court date now for the other matter that you're tying up your license?
No.
Okay, which court is it before?
It's from, I'm pretty sure City of Lansing.
Which judge?
I'm honestly, I don't know.
Oh, that's your. Can you pull a driving record? Okay, we'll come back to Ms. Dodge in just a moment.
Your Honor, I was able to find it. It looks like it's in front of Judge Flores.
Oh, it doesn't have to be open. Does she owe something on another matter? No,
Yes,
only-
there's an open judgment that is what is holding her license up.
We don't see that. She owes
Okay.
any money on anything else. What, do you have a case number of what you see before Flores?
Yes, just a second. Let me make sure it's the same judgment that's holding up the license.
It should be. It's the only one I've ever had.
Is it with Progressive
Progressive.
Michigan?
Correct.
Yep. It is 2200246 GC.
Okay, that's a civil matter.
Correct.
Okay. How does that tie up her license? You said that this is tied up your driver's license?
Correct. They suspended my license because of it. And I haven't been able to pay anything on it because I am a single mom and I'm homeless right now. So I'm working on it, but
Suspending her license for a civil matter? Does he have a court date on it? That's what I'm trying to find. Okay, and then you declined court appointed counsel?
correct. I didn't think it was like a complicated enough case to be on.
You didn't think it was complicated? Your license is
I mean, I just
is
thought it was
suspended
like,
because of a civil matter? Is that
Yeah.
what you're saying?
yes,
And you don't think that that's complicated enough that you need an attorney, huh?
I don't know.
Okay, sounds good. Give me 30 days.
It'll be May 16th,
I'm gonna set it for May 16th
9:30.
at 9:30. What are you gonna do to try to get that resolved, ma'am, between now and then?
I called Progressive. Me and them are playing phone tag. I'm trying to get something set up with them Because the court told me that it would be a lot simpler if we could work something out ourselves and just notify them, and then we don't have to do like the
Yeah, it's general civil
set something up
sanction
with the
here.
judge. So I'm trying to do that right now.
Okay, sounds good. We'll see you on May 16th at 9:30.
Alrighty. Thank you, Your Honor.
You're welcome. Okay, we're on the record in the matter of the people of the city of Lansing versus Sam Jones. The fourth, file number 23-00094, council appearance.
Matt Staples on behalf of the city of Lansing.
Assistant Public Defender John Lee on behalf of Sam Jones.
Okay, Mr. Jones, today is the date and the time that's set for a pretrial for a no ops in possession. Council, how are we proceeding on this?
Your Honor, Mr. Jones has informed me that he has been working with Wellness in regard to license restoration and currently is scheduled to meet with them on May 19th, after which he will be able to take all of his info over to the to the Secretary of State's office and complete his license restoration. So we're asking for an adjournment to allow time for that process to be completed.
You said he has an appointment when?
May 19th.
We can do May 30th at 9 o'clock.
May 30th at 9 a.m.
Thank you, Your Honor.
No problem. Do you have any questions today, Mr. Jones?
No, not at the moment. I appreciate it.
No problem. Any additional matters for the record, council?
Nothing for the city, Your Honor.
Nothing further, Your Honor.
Okay, you're all set, Mr. Jones. We'll see you next month.
All right, you guys have a good day.
Same to you. We're on the record in the matter of the people of the city of Lansing versus Carol Vandermoor, file number 23-00271, council appearance.
Matt Staples on behalf of the city of Lansing.
Assistant Public Defender John Lee on behalf of Carol Vandermoor.
Okay, it says the date and time that was set for a pretrial for a blood alcohol content 0.17 or higher and an open intoxicant driver. How are we proceeding?
But Your Honor, the prosecuting attorney and myself have reached a plea agreement. Ms. Vandermoor has agreed and signed off on it, by which she will plead guilty to operating while intoxicated first, all other charges to be dismissed.
Or that's correct, you want to accept the plea offer?
Yes, ma'am.
You raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under the penalty of perjury?
Yes, ma'am.
Thank you. You can put your hand down. Ms. Vandermoor, you have the following rights that you would need to give up before you can accept the offer. A, you have the right to proceed to a trial. You have the right to a jury trial. At the time of trial, you enjoy the right to the presumption of innocence. So you're innocent until the people can prove you guilty, and they have to prove you guilty by proving each element of the charges being brought against you beyond a reasonable doubt. Do you want to give up those rights today? Can you say that again?
Yes, ma'am. Sorry.
Thank you. Okay, and so that means that you're also going to give up your right to remain silent at a trial and not have silence be used against you. You're going to give up your right to cross-examine any of the witnesses the city intended to call. You're going to give up the right to call your own witnesses or present evidence that you believe would further a defense of this charge. You recognize that?
Yes.
Are you willing to give up those rights?
Yes, ma'am.
Okay. Anybody making any threats to you to get you to want to give up your rights today and plead guilty?
No.
Has there been any promises made to you in exchange for a guilty plea?
No,
Are you currently on probation, parole, or serving a sentence in another matter?
no, ma'am.
Okay. Are you on bond on any other matter? Is this the only one pending?
Yes, ma'am.
Okay, you understand that a guilty plea could result in a conviction that you may need to report to either your current employer or you may need to report a conviction on a future job application. Do you understand that?
Yes, ma'am.
And a guilty plea could have impact on any travel or immigration status you may be seeking. Do you understand that?
Yes, ma'am.
Are you entering a plea because you believe you're guilty?
Yes.
As to the amended count 1 of operating while intoxicated, first offense, how do you plead?
Guilty.
Have a factual basis, Mr. Lee?
Thank you, Your Honor. Ms. Vandermoor, on or about April 30th, 2022, were you driving in a vehicle at or near 3221 Rayborn Drive in the city of Lansing, County of Ingham, state of Michigan?
Yes.
And at that time, and that is a road that is generally open to the public and or for parking of vehicles, correct?
Yes.
Okay. And at that time, did you have a blood alcohol level greater than 0.08, the legal limit established by the state of Michigan for operating the vehicle?
Yes, sir.
No further questions, Your Honor.
Questions from you, Mr. Staples?
Nothing from the city, Your Honor.
The court is satisfied with the factual basis. I'll accept your plea. Find your plea to be made freely, voluntarily, and intelligently. This matter is set for sentencing. Sentencing is going to be June 13th, 2023 at 8:30 in the morning. Prior to sentencing, you are going to need to meet with our probation department. So you need to report to our probation department no later than 2 p.m. On Thursday of this week, so that they can set you up for an interview, okay? You need to report in person for them to set that up, okay?
Okay.
If you've already undergone a substance abuse assessment, that should be provided to probation so that they're not asking you to undergo a new one. If you have not had one, then the court's order is for you to have one, okay?
Yes, ma'am.
Do you have any questions at this time, ma'am?
No.
Any additional matters for the record, counsel?
Nothing from the city, Your Honor.
Nothing for the defense, Your Honor.
Okay, you're all set, ma'am. We'll see you at the time of your sentencing.
Thank you. Have a great day.
Same here. Okay, we're on the record in the matter of the people of the state of Michigan. I'm sorry, people of the city of Lansing versus Elijah Moore, file number 21L2690852. May I have your appearance, counsel?
Matt Staples on behalf of the city of Lansing.
Assistant Public Defender John Lee on behalf of Elijah Moore.
I was just gonna ask if he had an attorney, but we don't have an appearance from your office, Mr. Lee. Oh, no, yes, we do. Why is that not on here? Received on March 30th. As I say, Randall Hahn.
It was entered on 30th of January.
Not sure why it's not populating on the docket. Nonetheless, today was the date and time that was set for a pretrial and a failure to display operator's license. How are we proceeding on this?
Your Honor, I have not had a chance to consult with Mr. Moore, but it is my understanding that he has been incarcerated throughout the entirety of the time that these proceedings have been pending, and therefore would not have had a chance to obtain his license. If the court would allow, I can take a couple of minutes to speak with him to find out if that is entirely accurate.
Oh, sounds good. We will deal with that. And then I see, are you representing Eldon War?
Yes, ma'am.
And are you ready to proceed on his matter?
Yes, we are.
Okay, we're off the record on Mr. Moore, so we're on the record on the matter of the people of the city of Lansing versus Eldon Ronald Moore, file number 22-029 for a council appearance.
Matt Staples on behalf of the city of Lansing.
Assistant Public Defender John Lee on behalf of Eldon War.
Okay, today's the date and the time that was set for a pretrial. Okay, how are we proceeding on this?
Your Honor, Mr. Ward completed his assessment with the Community Mental Health on April 6th, 2023. I have been in communication with them and received an email their recommendations, but I do not yet have a copy of his actual assessment report. I have requested it and am seeking today a 1-week adjournment to allow time for that to be forwarded to myself and the prosecuting attorney.
April 18th at 11 a.m.
April 18th at 11 a.m. Mr. Ward, do you have any questions?
No, Your Honor.
Okay, any additional matters for the record, counsel?
Nothing for the city, Your Honor.
Nothing for the defense, Your Honor.
Okay, you're all set, Mr. Ward. We'll see you next week.
All right, thank you.
Okay, can we put Mr. Lee? Let's see. Who's on iPhone 13?
Hi. You
Hi,
guys, how you doing, Your Honor?
I'm doing well. How about yourself?
I'm doing good.
What's your name?
Travis Paris.
Okay, Travis Pierce. Okay, so I believe you're represented by Mr. Lee. And then I see a Moto G Power. What's your name?
Brian Varley.
Okay, Mr. Brawley, I think you're also represented by Mr. Lee.
Yeah.
What's your name? Yeah, and you here for court? Oh, okay, sounds good. Take that, Mr. Pearl. Are you joining us today? No? Yeah. I don't think I've ever seen him. Let's see here. Ooh. I don't think I've ever seen him. No. They failing to appear for me since February 2022. I don't even understand how we got here. There's that. Looks like our silver block is shorter than last time I saw it. It's not that much. On the record, in the matter, the people of the city of Lansing versus Elijah Moore. Mr. Moore, you can hear us, correct?
Yes, ma'am.
Okay, counsel, how do you want to proceed?
Your Honor, Mr. Moore, currently being incarcerated, is unable to move forward in the obtaining of his license. However, he does report that he actually has a job that requires a CDL license and an employer that is willing to help him obtain that license. Unfortunately, he is being held without bond pending sentencing on a case from 2019 and will not be able to move forward with obtaining his license until he is out of jail. So at this point, we would ask for an adjournment on this case with the understanding that we would like to file a motion to get his bond amended on case 20-00839-FY so that he can get some of these matters in order. He did voluntarily turn himself in, is my understanding, on the other case and wants to resolve that matter as it's almost 4 years old and he's in a very different position in his life right now. So that's kind of where we're at on the case, Your Honor.
Oh, that's in circuit court, got it.
My understanding is that he pled to a misdemeanor in that case and is scheduled. Let me just see when he's scheduled.
June 2nd.
June 2nd is what I show. And I show that hearing will be in front of you, Your Honor. But those are my notes. Those are not official records from the court.
Do you have a case number?
Yes. Case number 20-00839-FY.
This is bond.
Arraigned by Mary Kelly. Wait, what date was that? 27th March. Oh, all right. Can you pull that file for me? Okay, sounds good. I just want to know why it's on tonight. Okay, I'm gonna pull that file because I don't know why that file or that bond was denied. He does have a matter that's pending in circuit court as well, though, correct?
My understanding is that he has a matter pending at the 55th District Court here. I am not sure about the 30th Circuit Court here. I don't show anything in my records, but that doesn't mean that it doesn't exist.
Okay, Mr. Moore, do you have something pending in circuit court?
I don't believe so, no, Ms. Simmons.
Okay. Off the record, while we grab that file, I have Travis Paris and Brian Varley here. Did you need to speak with either of them?
I do need to speak with Mr. Paris, and we are prepared to proceed on Mr. Varley.
Okay, we're on the record in the matter of the people of the city of Lansing versus Brian Christopher Varley, file number 22L2736601, counsel appearance.
Matt Staples for the city of Lansing.
Assistant Public Defender John Lee on behalf of Brian Varley.
Today's the date and the time that was set for a pretrial on a failure to display operator's license. We adjourned this because he was taking his driver's exam on the 20th. How are we proceeding?
Thank you, Your Honor. Mr. Varley reports that he did take and passed his written test. However, he was informed by the Secretary of State that he needs a note from his doctor because he has medical conditions that require clearance from a doctor before he would be allowed to take his road test. The one wrinkle in that is that his primary care physician is not a psychiatrist, so he referred him to a place called Origami Rehab to be evaluated and get a letter from them. They charged $600 and he didn't have the money, so he applied for a grant. He was awarded that a grant. He got confirmation of that yesterday. So he now has the ability to go to Origami, be evaluated by them, and get the letter he needs to be able to complete the licensing process with the Secretary of State. So we're asking for an adjournment so that he can complete that process, Your Honor.
How much time are you asking for?
He has an appointment scheduled on April 18th, so I think 30 days would be sufficient, Your Honor.
May 16th at 9 a.m.
May 16th at 9 a.m.
Excellent. Thank you, Your Honor.
No problem. Do you have any questions today, Mr. Varley?
No, I do not.
Okay, any additional matters for the record, counsel?
Nothing from the city, Your Honor.
Nothing for the defense, Your Honor.
You're all set, Mr. Varley.
Okay, thank you.
I'll put Mr. Paris in room 1 with you, Mr. Lee.
Thank you, Your Honor.
I see a princess's iPad.
Jamal Tahir, Your Honor.
Oh, okay, very good. Thank you.
Yes, ma'am.
Good afternoon. I see Keith Cox.
Good afternoon.
Which matter do you have?
Judge, I'm appearing on behalf of Farm Bureau Insurance in the matter of Farm Bureau versus Rogers.
Okay, I see Mr. Brunette here on behalf of Laskew.
That is correct. Good afternoon, Your Honor.
Acceptance.
Good afternoon, Your Honor. Alexander Popov. I'm going to be on the credit acceptance fee to hear case, I believe.
Okay, sounds good. Thank you. Okay. That's fine. Be unable to be arraigned on March 23rd. You know why? Okay. We're back on the record in the matter of the people of the city of Lansing versus Elijah Moore. I have the file that's set for sentencing. The people of the state of Michigan versus Moore. That one, I wanted to see why he was without a bond on that, because he doesn't come to court.
That is correct, Your Honor.
That has been pending since 2020. It's 2023.
Yes, Your Honor, that is absolutely 100% correct.
Got a pre-failure to appears on that. And then I'm not sure why, because it doesn't make it clear to me. He wasn't available to be, or he was unable to be arraigned on the 23rd is the only note that I see. But it looks like he was arraigned by Magistrate Mary Kelly from the 27th and remanded. So if you want to make a motion on that file, we can do that, and then the prosecution, if they need to respond. Actually, this is set for sentencing, correct?
Yes.
Yeah.
Alternatively, Your Honor, if the court please, we would also be open to the idea of moving his sentencing hearing up. Because he's going to
He would
spend,
be interested in moving his sentencing to what?
moving his sentencing hearing up to an earlier date. He will probably spend almost, I don't know what the number is off the top of my head, but it's close to 90 days or more in jail before that hearing. So yeah, we would like to do something.
Oh, I don't even know. Jamie Nelson was on this. Okay, gotcha. Did he ever report to get to probation for his pre-sentence investigation?
I am unsure of that. Mr. Moore, have you been referred to probation or spoke with them about your pre-sentence investigation report?
No. When was that? When was I supposed to report?
Well, it would have been back in 2020, but since you've been incarcerated, it's possible that they would refer you from where you're at.
Okay.
Give me the sentencing date. It's the next available, it's fine with me. Reset his sentencing for April 18th at 8:30.
Excellent. Thank you, Your Honor.
No problem. There is a restitution order in here. So you should expect that he's going to be ordered to pay restitution to the alleged victim. Restitution in the amount of $1,004.18 was, I believe, the amount. Let's see here. And then we'll reset. The issue I have with resetting the other matter is he doesn't come to court. That's the whole, that's why we're here. If I reset this failure to display, do I gotta wait 3 more years for him to come back?
No, ma'am. I turned myself in because I'm ready to clean up everything that happened in the past. There's no reason for me to be honest, the reason why I didn't come to court all those years ago is because I was afraid. I was afraid of being in the same spot, and then I would also have to pay more money that I didn't have, which would put me in a lesser spot than what I am. It took me so long to turn myself in because I've found a good job now, so now I can pay what I owe. I have a 2-bedroom apartment now. So I'm not living with my mom, with my daughter. You know, I'm in a more comfortable position right now to take care of business, as you would say.
Where's your new
And
job?
I apologize. Excuse me.
Where's your new job?
It is Coremark, Coremark. Their transport depot is in Ohio, but we have a yard in Lansing that I get rides to and from, and then we travel. And they pay me good enough so I could take care of my life queue debt and get a 2-bedroom apartment and lease a new vehicle. So I'm not afraid to pay, especially what I owe. And I'm here to I turn myself in to take care of the matters from the past, because there's no reason why I should be missing court dates or being a wanted man and all that. I'm a single dad, and like Mr. Lee said, my situation has turned for the better, and I don't want to mess it up.
Sounds good. There's some people in the courtroom for you today. Who are these people?
This should be my mom and my girl.
Well, sounds like there's a difference of opinion of relationship status, but I'll let you guys work on that on your own. We don't need to put all that in the record. Nonetheless, supporters nonetheless. Give me a date for the failure to display out. So you need to get a CDL for the new job?
I don't. Right now, I'm a driver in training, so I gotta work 6 months accumulated in order to get enough drive time to for them to pay for my CDL. And then I would be locked in under contract with them for 2 years.
Oh, gotcha. Mr. Lee, you weren't asking for me to adjourn this for 6 months though, correct? What did you want me to
No, Your
adjourn the
Honor.
film?
No, just long enough for him to be able to get out of jail and go to the Secretary of State and complete the restoration process there, probably 30 or 45 days.
Should be less.
Okay.
I'll make it less.
I'm going to amend the bond on the state file. Well, I'm going to give him a bond because he didn't have a bond. A $500 personal recognizance. You need to appear to court for all of your future court dates. Your next court date again is April 18th at 8:30. You can't appear via Zoom for your sentencing, okay?
I understand that. Thank you very much.
Okay, and then as to the failure to display ops, you'll need time to get with Secretary of State because they don't move that quickly. You have 30 days.
May 16th at 9 a.m.
May 16th at 9 a.m. will be the date on the city matter, okay?
Yes, ma'am.
So you can be released on your own recognizance today on the other file, and then we'll see you in court on the 18th of April on that state file and for the sentencing. And then we'll see you on May 16th on the failure to display ops, okay?
Yes, ma'am. Thank you very much.
You're welcome. Do you have any questions today, sir?
None at all. You answered all of them. Thank you.
Okay, let me get your phone number and address again in case we gotta send people to track you down.
Okay. Are you ready?
Correct.
Phone number is 517-894-6611.
66 what?
6611.
Got it. They put too many numbers in this phone number. That would have been sketchy. Okay, and then your address is the address on Viola?
No, I just moved recently to a new apartment. The address of that is.
Why did you say she confirmed address? Yeah, she put her note that she confirmed the address, but I don't see it updated. This one has fire. Okay, what's your address, sir?
201. I don't know if I think it's South Waverly or it's just Waverly Road. It's on the corner of the name of the apartments.
Is it an apartment number?
Apartment A11. It's on the corner of Michigan Avenue and Waverly.
Okay, yeah, we need it really so that we can mail your notice to appear. We don't want it to go to the wrong address.
I understand.
So if you get out today and you go to your house and you say, and you realize that you gave us the wrong address, what do you gotta do?
Call you guys and update it?
Facts. All right, do you have any questions?
No, ma'am.
Okay. Any additional matters for the record, counsel?
Nothing for the city.
Nothing for the defense, Your Honor.
Thank you. We'll see you on April 18th and and then May 16th, sir.
Thank you so much, Ms. Simmons, and thank you very much, Mr. Lee.
Thank you. And I'm Judge Simmons, by the way.
Sorry, Judge.
Thank you. Have a good one.
Thank you.
Okay, I'm issuing a bench warrant for Robert Pearl. Okay, let's see, Mr. Pierce, and then we're on the record in the matter of the people of the city of Lansing versus Travis Alon Paris, file number 23-00203, council appearance.
Matt Staples on behalf of the city of Lansing.
Assistant Public Defender John Lee on behalf of Travis Paris. I am substituting for Sarah Donnelly on this matter, Your Honor.
Thank you. Today was the date that was set for a pre-trial, and this matter was reset so that we could wait for a substance abuse assessment. How are we proceeding?
Your Honor, Mr. Paris has been referred to PATS via a grant program that allows him to get the substance abuse assessment free of charge. He reports that he is going to PATS tomorrow morning to get this completed. Apparently there was some paperwork and or communication that had to occur to make this happen, which accounts for the lapse of time. So we are requesting one more adjournment, Your Honor.
I don't know about that because let's see. Okay, yeah, let's do that. I couldn't hear because something's going on with the drug. Okay, May 16th at what time? 9 a.m. May 16th at 9 a.m. Mr. Paris, do you have any questions? You're muted, Mr. Paris.
No, I don't, Your Honor.
Okay, any additional matters for the record, counsel?
Nothing from the city, Your Honor.
Nothing for the defense. Thank you, Your Honor.
Okay, we'll see you next month, Mr. Paris.
All right.
Okay, is that all that I have for city matters? I think so.
All right. Thank you, Your Honor. Have a great day.
Thank you. Thank you, Mr. Lee.
Thank you, Your Honor.
Okay, Mr. I don't see Mr.
Douglas Jackson. Is he in the hallway maybe? Yeah. Okay, Douglas Jackson failed to appear for the creditor's exam. A show cause can issue.
Thank you, Your Honor. Is it okay if we serve the show cause by mail?
That is correct.
Okay. I believe that is all I have. Thank you, Your Honor.
Thank you. Have a good one.
You too.
On the record in the matter of Credit Acceptance Corporation versus Jamal Tahir, file number is 16-03987 GCE. Council appearance.
Good afternoon, Your Honor. Alexander Pop-Up, PA 4378, up here on behalf of plaintiff.
Okay, and Mr. Tahir is present via Zoom. Mr. Tahir, do you have an attorney representing you at all? You're muted. You have to unmute. Yeah, you have to unmute.
Okay, I'm muted now. How you doing? How are you, Your Honor?
I'm doing well. How are you?
It could be better. I would like to have a chance to explain my side of story, if you don't mind, Your Honor. With all due respect.
I don't mind at all. I just want you're representing yourself, correct, sir?
Yes, ma'am. Yes, Your Honor.
Okay, so you filed a motion or an objection, that is, to a garnishment. You stated here that the funds are exempt from garnishment by law. So can you explain?
Yes, ma'am. For the first time, as you can see, I just received this contract with the credit acceptance, and there's a fraud. There's a fraud involved when it comes to the down payment, that $1,800, and also I would like to review this case more with the Attorney General's office involved. They are reviewing this case because of in 2015 there was a car that I have test drive. It was 2009 Dodge Charger, black color, 100,000 miles on it. But I was told by the Riyadh Muhammad Michi, which is the dealer at that time, he told me that I can pick it up the car after they finish with the braking and the rotor. And a week later, he delivered the car, different car, which is 2006 and 177,000 miles, and it had a lot of issue in it. That's not the car that I signed. As you can see, Your Honor, I don't know if you can see my screen.
I didn't want to break your flow, but you keep holding up a document like I can see what you're holding up. I can't read that. I have no idea what you're holding up.
Yes, ma'am. You should have the copy of right there, the contract. You see that? You don't see my signature. That's not my signature. I didn't sign for this car, Your Honor.
What I don't have what's in your hand. What is that?
It's a contract was between about the car that they sued me for. But this is not even my signature.
Why do you believe that I have that? Did you file a copy of that with your objection?
Yes, ma'am. The court gave me this. The court gave me this because the credit acceptance wouldn't let me have this contract because they knew what they did is a fraud. So my point is the car was not repo because I didn't have the car. They gave me a wrong car, but not the car that I signed for.
Okay. I don't have whatever it is that you're showing. I don't have that in my file, so I don't know what that is, and I can't see just because you posted up to a camera. I can't read that. If you want to use something as an exhibit and show it to a court, you have to file it. That's what the court rules say. Okay.
Okay, but this is the court your court gave me the other day. This
I don't know who gave that to you. I don't have a copy of it in my file. Is what I'm saying. I have no idea who gave that to you or where it came from.
From the 54 the downtown court, I think the
That's
fifth
where we're
floor.
located, but again, that's not in my file. So I can't tell you what that is.
Can you, I would like, Your Honor, with all due respect, please, can you review this? Because there's a fraud have been made out of this
I
case.
can't review anything that's through a computer. I can't review that. I don't have it.
Okay, is there any way we can have another appointment so I can show you face to face?
Your Honor, if I may.
Okay. You may.
On his original objection, he filed an objection saying that the funds were exempt. And he's not saying anything about any exempt funds. And furthermore, the funds aren't exempt. Second, right now he's attacking the underlying judgment, and I don't believe this is the appropriate motion for that.
Objection. How am I attacking I'm reporting the crime that the credit acceptance have done. This, I never had this down payment. 1,800, they put it here. This is a fraud, Your Honor. Fraud.
Okay. First of all, today was the date and time that was set for a hearing on an objection.
Yes,
again, and I stated that to you in the beginning. You filed an objection to a garnishment. You selected the option because it gives you 6 options. You selected the option that the funds or the property are exempt or protected from garnishment by law. Today is the day for you to tell me why, under the law, these funds are exempt. What you're saying to me, and I don't know if you have a pending matter with the Attorney General's office or not as it relates to fraud. If that's the case, what you're alleging is that the judgment is fraudulent.
Yes, ma'am.
That's what you're alleging.
Yes, Your Honor.
That is what Mr. Popoff is saying, is that you're attacking the judgment. You're saying it's fraudulent. And he is correct by law, and you should have reviewed the court rules before you filed this motion or the objection. It clearly states there, you cannot use this objection to garnishment to attack the judgment. This is not the proper forum to do that, sir.
I apologize, Your Honor. With all due respect, this is my first time appearing about this case.
I recognize that.
They claim that they have served me, in which I was in Tennessee that time in 2016. I don't know who they served at that time. This is my first time ever obtaining this copy of their contract. And this is my first time ever appearing to you, Your Honor. And so I would like to have a chance before this individuals that, they want to take our tax return. I have a wife that with breast cancer, her name Brittany, and I have a toddler. So there's no way I would pay for something that I never owned. And also they have made it a fraud right here. And I have a proof of this fraud. I'm not trying to attack the judgment, but what my point is, they taking my money without me, my side of the story being even heard. The point I have here is, and they knew that they in 20 if you give me a chance, maybe 30 seconds, I can explain it to you very short.
I'm listening.
Yes, ma'am. So in 2015, there's a car that I test drive, which is 2009 Dodge Charger and a black color, and it had 100,000 miles on it. And by the time I signed, that's the car I knew I signed for. Now this is here's the very interesting part right there, Your Honor. So I was told that the dealer, which is Riyad Mohammed Radal Michi, and he said he gonna fix the brakes and then he gonna call me so I can come pick it up. That didn't happen, Your Honor. What happened was I was given after 1 week later, I was given to this card that now they credit acceptance sued me. So this card that I never signed, I want to show you because there's no signature.
Let me stop you. I can't read that document through the computer. I already said that. You also, in the 30 seconds I just gave you, you absolutely repeated everything you already said, which still brings us back to the point that you're trying to attack the judgment. There was a default judgment that was entered against you back in 2017. And so if you want to attack the judgment, you can't do that under the objection.
I
You got
apologize.
to find another way to do it, okay?
I apologize. I'm not trying to attack, but I'm just saying like the Michigan
No.
legislature.
You're disputing the judgment. You're saying it's fraud. I don't know if it is or not. I don't know if the underlying contract was fraud or not. I know that they got a default judgment because you failed to appear in court after being served. What I do know is that per the court rules, you cannot file an objection to a garnishment to now use that to prove that the case was fraud. You can't do it that way, okay? So I'm denying your objection because it violates the court rules, okay?
But Your Honor, with all due respect, there was given judgment.
I don't believe you're disrespecting. I think you misunderstand. What you're trying to do violates the court rules. You can't do it that way. So if you have something pending with the Attorney General's office to address your claim that this was fraudulent, then you're going to need to work that out that way. But you can't use the objection for that purpose, especially under the exemption from law selection that you made. Okay.
Okay. I might maybe misunderstood that part, but Your Honor, can you give me more time before you release this money for them, please?
I cannot give you more time because you haven't provided me any information where I can give you relief under the law. I have to follow the law.
Yes, ma'am.
It can't be. No, that won't help me because what that looks like is the document that you want me to read that you believe shows that there was some fraud. And
yes,
there may have been some fraud. I don't know because I didn't even handle the underlying matter. All I know was that there was a default judgment long before I was even a judge on this case. What I can tell you is that if you believe you can prove fraud, you should probably try to do that, but you can't do that with an objection though. You can't do it here with that.
Oh, yes, ma'am. I want to prove to you. I'm sorry, cut you off. I apologize. I want to prove this to you, Your Honor. This is my first time ever appearing in court, and I don't know how the system goes. You guys know more than me, but I apologize for any inconvenience. But I can show the proof that there's a fraud being made. I can show proof that I did not sign for this car, Your Honor. Okay. I did not sign for this car.
Okay, so I hear what you're saying. At this time, I find that per law, your objections are invalid. And so the objections are going to be denied at this time, okay?
Your Honor, the reason this is my first time ever appealing.
I recognize that you've told me that multiple times. I recognize that's your first time. That's how you got a default. You didn't appear in court.
Yes, ma'am. I didn't even know I had a court before. That's what I was out of state
personally back in 2016.
Yes, ma'am. But they claimed that they served me, but I was not even in Michigan, Your Honor. Please.
Okay, well, they have a proof of service that's signed by and notarized actually that said that you were served personally.
But so I know that's
here. And then once there was a judgment, a default judgment, you would have been notified of a judgment via the mail. We haven't heard from you until they garnished the wages. So you didn't even contact once you were told that there was a judgment. There would have been or should have been noticed you sent years ago that you had a judgment. Okay.
Yes, ma'am. This is why I say like I was not in Michigan at all. This is me right now. Seeing for the first time I've seen this contract. So I know you cannot read it through the computer.
I understand, but I'm not able to help you with what you're trying to do. You're trying to attack the judgment by objecting to a garnishment, and the court rules say you can't do that, okay?
So how can I have a fair trial, Your Honor?
You're not gonna a trial on this. You don't have. This is a judgment already. If you want to address what you got going on, you said you're already working with the Attorney General's office. You probably want to get you an attorney if you don't have one. If you're trying to prove some fraud, I think you got a uphill battle against you at this time, okay?
So how can we going to release this money to the individuals that fraud?
You have not provided the court with any valid reason to believe that the garnishment was invalid. And so the objections are invalid, and so the monies were released, okay?
Your Honor,
to satisfy the judgment.
How can you release the money without you even reviewing the contract? Your
I
Honor?
don't have to read that. I have explained that. I don't have to read that because it has nothing to do with the garnishment. That has to do with what you believe will show that the judgment is invalid, and you can't object to a garnishment and then try to attack the judgment through the objection, is what I'm trying to tell you. And I don't know how any other ways for me to explain that to you, sir.
But the whole purpose is starting like, that's why I need more time so I can bring an attorney. Your Honor, this is a fraud.
Well, you filed this objection and you knew what you were coming for today. And so we can't delay this so that you can now go find an attorney, just so the attorney can tell you the same thing about the rules of law as it relates to objecting to a garnishment. The court rule is very clear as to how you and when you can object to a garnishment, and when the court can grant it, and when you and if you can use that to attack a judgment. And when I say attack a judgment, that means you object and you say that the garnishment is invalid because the judgment was fraud. That you can't do that. The court.
Okay, how can I prove that then, Your Honor, please?
I can't advise. I can't give you any legal advice about how you can prove your case. Okay, sir.
So they was given a judgment without me being even present at the
Yeah,
court.
there was a default judgment because you failed to appear. Correct.
I was not in the state, Your Honor. I apologize about that, but I would like to have a given chance by now so I can show you the proof of me not signing. The proof
there was a statutory time frame whereby you could have appeared after the default and asked to have it set aside, and you could have notified the court and let them know you didn't live there. That never happened. And so we can't come 7 years later and have a trial on a default judgment. The default stands. If you want to prove fraud in another way and pursue the plaintiff in another way, that's your prerogative, and you have the right to access the courts in that regard. But you don't have the right to misconstrue the court rules to your benefit at this time. Do you understand that?
No, ma'am. I respect what you're saying, ma'am, but I wish you can review. You see, I'm a victim here. This is what, like, I understand. You know,
I'm not disputing that. I don't know what happened. Nothing actually. There was no trial, so I don't know if you were a victim or not. What I'm telling you is that you cannot do what you're trying to do to prove that you were a victim. Is what I'm telling you.
How can I prove
So you
it then,
need to
Your
go
Honor?
get an attorney. You need to go get an attorney and then figure out how to handle it. Okay.
So after you release the money, how, you know, like, you think that's possible? So if you're releasing the money right now for the individuals that fraud me, so how can I prove
The
that?
garnishment, the judgment has been pending for over 7 years at this point. The garnishment was already issued, and you waited until now to even bring this issue before the court. So if a garnishment is released to them, it's because you sat on the judgment for this long.
Yes, ma'am.
So you need.
Your Honor,
Under the law,
I was not even in the state, Your Honor. I'm sorry.
I recognize that. At this time, I need to move on to another case. I can't keep repeating the same things. Maybe if you hire an attorney, they can explain it better for you. Okay.
So can we please hold it for the fund, please? I
can't hold the funds while you go and find legal counsel. I can't do that.
Well, can I show you? At least you don't even have the copy of it.
No, because all that is to show me that you believe that the judgment was fraud. That's what you're trying to show me. You believe that the case was fraud.
I'm not attacking your court, Your Honor. I'm talking about what credit acceptance show you is a fraud.
I don't even know that credit acceptance didn't even show us that. That's not in our file. So that's not so. Showing me that's not going to help you.
Your Honor, your court gave me the other day.
Showing me that's not going to help you, sir. We're off the record.
Thank you, Your Honor.
on the record in the matter of the Farm Bureau Insurance of Michigan versus Lasherion Marquise Rogers. File number 22-02133 GC, counsel appearance.
Good afternoon, Your Honor. May it please the court, Keith Cox of Winters and Associates on behalf of the plaintiff, P59146.
Okay, Mr. Rogers, can you hear me?
Yes, I can, Your Honor.
Thank you. Today was the date and the time that was set for a motion to set aside default judgment. Mr. Rogers, we previously had a motion to set aside default judgment, I believe, and I think you failed to appear. Is that correct?
Yes, ma'am. Yes, Your Honor.
Why didn't you appear?
So I lost my job due to not having a license, and I got a new job working nights, and I got, instead of having like Friday and instead of having Sundays off, I have Friday and Saturday off. So I work Sunday night and then I work that next night, and I just got my days confused, like, because my week's off. I have Fridays off now instead of Friday, you know, where I worked Fridays before. And I showed up to court, but I came the day after.
Your court date was on a Thursday.
Yeah, so I came on Friday. That was just a day off. I was like a day behind. Like I thought it was Wednesday.
You're saying you came the next day?
Yeah, I came up there the next day and they told me I had missed court.
Why is your notice of hearing dated for the 21st then?
What's it? You said why
you were supposed to be here on March 2nd. You didn't appear, and you didn't file anything else until March 22nd.
Because that day I didn't bring the proper stuff to file the paperwork to do it. Like I got a hold of my attorney, and my attorney told me to basically refile the judgment, and I got legal advice after that because I thought I was pretty much screwed.
Oh, so you have an attorney representing you in this matter?
I do. He's not here today. I was just told to basically see what I could do about getting my license back and then follow up with him before I gave him.
The attorney is representing you in this matter or in getting your license back?
It represented me in this matter.
Okay, what's your attorney's name?
Michael Mataloni.
Okay, Mr. Mataloni is representing. Does he know that he's representing you?
Yes.
You paid him to be here today?
No, he hasn't gotten paid yet. That's why he wanted me to see about what I could do to get my license back and then go from there, because he didn't want me to pay him basically if I didn't need to, basically. Like he's been my attorney for years, so.
Gotcha. What is your meritorious defense to the actual lawsuit?
Well, actually, it's slightly correct, but it's not. I was actually hit, and the story for the report is kind of off, but I got witnesses for that, and I have a bill for my trailer where my trailer received damages, and I have a whole defense to that, but I don't know if that's something I can settle now or if that's something I have to wait.
I'm asking you what your meritorious defense is, because I have to know what it is before I can decide if I can even grant your motion to set aside default judgment.
Okay. So basically, I don't know if you got the report there in front of you or not, but I was in the left lane headed northbound on MLK. She was behind me actually. And as we're coming up on where it goes from 2 lanes to 1 lane, she decides that I'm in a truck and a trailer. It's a 26-foot trailer, and because I own a transport company. So she decides that she's gonna try and go around me and come around me, and ended up running into the back corner of my trailer. And what it did, it didn't even do really any damage to her car. That's why it says right in the report it was light damage. It literally put like some buff marks on her door. Like, you know, there wasn't even a dented quarter in her car or anything. It was like literally just from my tires on the trailer rubbing like the side of her car, you know. But where she's saying, you know, basically like I ran into her, that would make no sense, because how did you run into my trailer if I ran into you? You know, like if you were beside me and I tried to speed up to pass you, how did a truck and a trailer beat you in a car and you ran into the trailer, not the truck, you know? And you have to yield to merging traffic. If it says, I have pictures of the sign, the intersection, all that, it says left lane has to, you know, left lane merge right. You have to yield to merging traffic. So, you know, for her to try and come around me knowing that the lane ended and there's signs on both sides of the road saying that, you know, I wasn't cited a ticket for the accident at the accident. Like I wasn't declared at fault.
Mr. Cox.
Well, I think the court asked the question about good cause for the defendant's failure to appear at his first motion, but I don't think what the court asked was why the defendant didn't file an answer to the original lawsuit and didn't file a timely motion after default judgment was entered against him. I'm looking at the proof of service with regards to the affidavit of personal service. It lists the same address as is on his current motion. So plaintiff's convinced that the process server at least filed a proof of service, if not personally served him at the address that he currently resides. And then the court would then have also mailed a copy of the default judgment to that very same address. So plaintiff's position is at a minimum, he had notice of the entry of the judgment against him going back to December. But we believe he was personally served, and he hasn't really set forth a valid good cause as to why he can come forward and contest the lawsuit or file a timely answer with the court or file a timely motion to come forth with his first motion to object to the entry of the default judgment against him. I guess secondarily, I'm looking at the police report, and I think it tells a different tale than what's being represented. It almost sounds like he's reversing the 2 unit numbers on the report, because the unit 2, which is plaintiff's insured, had the right of way going straight, and it was his vehicle that had to merge. And the diagram and the physical description by the officer indicated that he cut off the defendant or the insured and caused the accident. So, you know, and was listed to be at fault because on the report it indicates that it was the defendant was characterized as improper lane use, but would have been the one that caused the accident. So I don't think there's been good cause or meritorious defense. And then to go all the way back to the very first issue raised, my office did communicate with Mr. Rogers last week. And he did put a down payment toward this judgment balance and set up an installment payment arrangement.
That's for the wrong case.
Which caused my office to release the abstract of court record, which is the suspension of his license. And frankly, we went ahead and did that on April 6th. So I don't know that the petition to withdraw abstract has been received by the court yet, but I suppose that's not really what's before the court, but I would note that seemed to be what he indicated at the beginning of the hearing was one of his primary goals. So I would indicate that's already been accomplished.
Mr. Cox?
Yeah, excuse me,
Can you hear me?
the court, sir?
Yes,
You address the court, you don't address Mr. Cox.
Okay. Sorry about that. So I did pay them $400. I made a payment of that last week, and that was actually because that's part of the reason also I missed a judgment is because when I got basically given the papers or whatever, served the papers, I was actually on the highway literally getting ready to go out of town because I transport. So I was out of town for a time, you know, in and out of town or whatever, and I called because I misplaced the papers that he had given me, and they gave me the court date to my other case that I have with them. So I ended up showing up for one court date thinking I'm taking care of this, and I was taking care of the other court case, which is the same thing that happened with that payment. That payment wasn't supposed to go to this case. It was supposed to go to the other case that I already have settled with them. So it's kind of a this back and forth thing. Like every time I call on the case, they get the case numbers mixed up, between the two.
He has more than one case pending with your client?
Yes, Your Honor. He was involved in two separate automobile accidents, one from August 9th of 2021, and then one from November 30th of 2021. Both involved him negligently operating an uninsured motor vehicle. The first one was for a 1997 Cadillac DeVille, and the second one was for a 2003 Chevy pickup. The first case was settled by way of a consent judgment. This case went to a default judgment. But it was only the second case, the default judgment case that I just referenced, where the abstract of court record was filed on the basis of his non-response to that suit.
Okay. Mr. Rogers, I just wanted to highlight, just because you brought up the crash report, it does say here that you had some improper lane use. It says that on the crash report.
Okay, so I wasn't cited a ticket for that, but it was kind of more so.
That's at the officer's discretion.
Okay,
the diagram also in the depiction there was on the second page of the crash report would also further that the plaintiff was driving in the lane and you attempted to try to cut her off, and that's how the accident occurred. Nonetheless, before I could grant what you're requesting, which is to set aside a default judgment, I need to make a ruling as to whether or not I believe you had good cause and then a meritorious defense. I think your defense is a little weak, but the issue I have, the bigger issue I have is good cause, because you failed to respond to the complaint. Then once a default judgment was entered, you appeared and you requested to have the default judgment set aside. Then you failed to appear for that court date, and then you said you appeared the next day, but it was the next filing we had from you came a couple weeks later, and this paper came from the court anyway. So I don't know why you say you didn't have the proper paperwork to appear. If you had came into the court the very next day after you were supposed to appear because maybe you misconstrued some dates, then we could have gotten that reset, because that's our normal practice. We would have gotten a reset. We would have let Mr. Cox be made aware of that, because it doesn't even appear that I had signed an order that quickly after the second. If you had came in on March 3rd, but you didn't. You waited until March 21st.
I came in and I was told
to then file something else. So I don't believe you have good cause. You're not giving me anything to believe that you handled this case appropriately, and then you tell me you had an attorney all this time.
I never had a hired attorney all this time. I just had attorney advice. But I did come in, but I was told that I had to repay a filing fee. Basically, it was like the $22 or whatever it is, and I had to have a stamp and all that stuff, which I could have got there. But at the time, I didn't even have the cash on me to do it. Like, I was just more so wanting to clear my name. I thought I was gonna have a warrant and all that behind it, so I just wanted to make sure that was, cleared and taken care of. And then, like I said, I'm normally on the road.
So you wouldn't have gotten a warrant at all. But if you came in on this, if you came in after not appearing in this case and getting a default judgment, and you say that you want the judgment set aside, and you are given a hearing date, you needed to have appeared for that hearing date. When you didn't do that, you said you came the next day. Even if you didn't have the $22, you didn't come back until the 21st. 3 weeks later.
You're right,
3 weeks later. So I don't believe you have good cause, and for that reason, and your meritorious defense is pretty weak as well, just based on what was been attached to this case as a part of the filing, which was the crash report. So for that reason, I have to deny your motion to set aside the default judgment. And you can probably work out a payment arrangement or a way to resolve this with the plaintiff, and that will address your license issue if that's what your goal is. But setting aside this case so that we can get back to you missing court and or not being able to provide a meritorious defense is not going to be meaningful.
Well, Your Honor, I did call and try to at the time because I was told it was going to take a month for me to even get in to see a judge on this matter. I tried in multiple ways, which I have the contact, history and all that of trying to call this office week after week, got no call back. I ended up driving out to their office in Southfield or whatever and going up there, and we ended up knocking on the door, which there was a sign on the door saying that their office is closed. I just so happened to catch the secretary walking in. We ended up coming up with an agreement. They took copies of the papers that I had, all that. I was supposed to give them $300 to get my license back. When I called back to try and pay the $300, they're telling me they had no record of the $300 agreement or whatever, and they wanted me to pay $700. Then when I talked to them a week ago, it was $1,000. Like I had to pay $1,000. So it's like the number just keeps fluctuating. I don't know who I'm talking to. Like,
but that's not, your license is not being tied up on this case. That's another case you're talking about, correct?
no, my license is tied up off this case.
Judge,
The other case has nothing to do with my license. They never took my license for that.
That's correct, Judge. Our office on this file filed an abstract of court record back in January. And I think it should be reflected in the court file. But our office did contact Mr. Rogers did contact our office, and an agreement was reached that he would put $300 down and pay $100 a month for a reinstatement of his license. Based on that agreement, our office has filed a petition to withdraw abstract of court record. It's dated April 6th. I assume it went in the mail on that date, so that should be coming to the court shortly. And Mr. Rogers paid us $400, which I think constituted both the $300 down and then the first $100 payment, it looks to me. So I think
okay, so that was on this file then, because he told me previously that wasn't on this file.
I think
no,
he said he was confused as to which file it was on, but the other file, there was a consent judgment where he has defaulted on the payment plan on that.
And that's where the payment was supposed to go to.
Well, the notes I have on the account say that you contacted our office on this very file on the basis that your license had been suspended, and it was suspended on this file, and that you took steps to reinstate your license, which appear to have been successful in the case. On the other file, I think you find yourself in default of the consent judgment and need to address that file on the basis that you could find yourself, unfortunately, in a similar situation, if not addressed, where they
well,
could.
when I paid the $400 online, that's the case I thought it was.
Okay, well, this is what I think happened. I think that I've given my order, and so you all can talk